Section 199 of the Constitution regulates the establishment, structuring and conduct of the security services, a single defence force, a single police service and any intelligence established in terms of the Constitution.
Have you not left out services of the intelligence, or am I wrong?
I believe that's a typing error,
No,
Chair. You are correct, yes. All of these services are structured and regulated in terms of national legislation. Section 199(6) of the Constitution provides that no member of the security services may obey a manifestly illegal order. In terms of Section 199(7) of the Constitution, members of any security service must always act in accordance with the Constitution and the law, and may not act to either prejudice a political party's interest that is legitimate in terms of a constitution, or further, in a partisan manner, any interest of a political party. The Police Act is the legislation contemplated in Section 199 of the Constitution that provides for national legislation must regulate the security services. In terms of the preamble of the Police Act, provision is made for the establishment, organisation, regulation and control of the police. It determines the terms of office of commissioners, the National Commissioner and Provincial Commissioners in Section 7, the recruitment and appointment procedures of members in Section 28. It also sets out the powers, duties and functions of respective functionaries and members in Sections 11 to 15. It provides for the authority to issue national instructions and orders in terms of Section 25, and it provides for disciplinary proceedings in terms of Section 40.
Yeah. Then you next deal with the key SAPS role players. And the first key role player there is the Minister of Police. If I can ask you to proceed from paragraph 20, and just note the date there that needs to be corrected when you deal with that paragraph.
Mr. Sensum Kunu was sworn in as the Minister of Police on the 3rd of July 2024. The typing error, the glaring typing error should be excused. And this is important because in terms of Section 95 of the Constitution, before a minister begins his tenure or begins to perform his functions, he must be sworn in. So that means once he's been sworn in, he is the Minister of Police. And it means that the term of office of Minister Nkunu started on the 3rd of July last year. He swears faithfulness to the Republic and obedience to the Constitution. On the 13th of July this year, Minister Nkunu was placed on leave of absence with immediate effect, and the President appointed Professor Feroz Kachalia as the Acting Minister of Police in terms of Section 91(3)(c) of the Constitution. The powers and functions of the Minister of Police in South Africa are primarily defined by the Constitution as discussed above and in terms of the Police Act. The Minister's role is to provide political oversight and to determine national policing policy, while operational control of the police service is vested in the National Commissioner. The Minister's key powers and functions involve the following. The Minister is responsible to formulate national policing policy in consultation with the provincial governments. This ensures an overall strategic direction of the police. This ensures that the overall strategic direction of the police service is aligned to national priorities in accordance with Section 206 of the Constitution. And in this regard, it should be noted that the Civilian Secretariat for Police Service has drafted various policy documents for approval by the Minister. It includes, for example, a policy on the reduction of barriers in the reporting of sexual offences and domestic violence. This policy aims, inter alia, to strengthen of efforts to prevent and deter sexual offences and domestic violence by broadening and deepening the collection of information about such crimes, and to increase the access of victims to justice by reducing barriers to the reporting of sexual offences and domestic violence. A policy, once approved by the Minister, will require the National Commissioner to take steps for implementation and operationalisation. It should further be noted that the national policing policy, as envisaged in Section 207(2), was only approved in Parliament in Cabinet in July of this year.
Now, can I ask you,
General, please pause there for a moment. The policies you refer to in paragraph 22.1, do you have sight of them before they go to the Minister for approval? What happens after the Civilian Secretariat has drafted those policies?
Part of the drafting process involves consultation. So even in the deliberations of a policy, the police will be roped in, so that we also deal with policing aspects, because it's no use to issue a policy that's not implementable and practical for the police service. So once the Civilian Secretariat has completed the draft document, it will be submitted to the Minister for his approval. Once it has been approved, it will be submitted to the National Commissioner with an official letter indicating that this has now been approved, and the implementation plans should be drafted to ensure the effective implementation of the policy. National policing policy, the one that was approved in July, indicates 4 policy areas, and it's high-level areas. It relates, first of all, to effective policing. The second area, and there's a number of recommendations, but it just indicates the strategic level of a document. The second one relates to service delivery. The third one relates to community involvement and the need to have participation of the community in respect of matters relating to police. And the fourth one deals with ethical and strong leadership in the department. So those are the four pillars or policy areas specifically addressed in the national policing policy.
Yes. What exactly does service delivery deal with or relate to?
There's a number of issues. For example, the treatment of complainants and the need to consider their privacy and to make sure that there's feedback given to a complainant once a case has been reported. It also deals with effectiveness in the gathering of evidence and the analysis of evidence during an investigation. So it basically deals with the delivery of policing services, whether it relates to crime prevention and our engagement with schools and other entities in respect of crime prevention, or whether it deals with the effectiveness of detectives and the manner in which investigations are conducted, including matters such as the analysis of forensic services, the DNA, the ballistics, and how the services in that regard can be addressed to ensure improvement and promotion of effective policing.
Thank you, Mr. Mtel. General, in the absence of national policing policy, which you say was approved by Cabinet only now in 2025, what has guided the police in the everyday operations or work that they do?
Keep in mind, Commissioner, that this relates specifically to the role of a minister.
The minister's key powers and functions. If I can ask you to proceed from paragraph 22.2.
The minister is the cabinet member responsible for policing and oversees the Department of Police. The National Commissioner reports directly to the minister in terms of Section 207 of the Constitution. The minister also has the authority to make regulations on a wide range of matters to ensure the proper implementation and administration of the Police Act, and this is provided for in Section 24 of the Police Act. The minister has, for example, issued regulations on matters such as discipline, employment, municipal police service, and reservist, just to mention a few. In addition, several key entities report to the minister. Their functions are regulated by separate legislation, but the minister provides overall strategic direction and oversight. These departments and entities are as follows. The Civilian Secretariat for Police Service, they are responsible...
So that's CSPS?
CSPS, yes.
Okay.
They conduct civilian oversight of the police and provides policy and strategic support to the minister. They are also responsible to give strategic advice to the minister in respect of the development and implementation of policies. It also monitors the performance and compliance of the police with policy directives and monitors the performance of the police service and regularly assess the extent to which the police service has adequate policies and effective systems, and they can make recommendations for corrective measures. The second department, apart from the Civilian Secretariat, is the Independent Police Investigative Directorate, commonly referred to as IPID. They are an independent body that investigates serious crime and misconduct committed by members of the police and municipal police service. The minister plays a role in the appointment and suspension of its leadership. So it's important, Chair, to take note that in the Ministry of Police there are three departments: the South African Police Service, the Civilian Secretariat of Police, and the Independent Police Investigative Directorate. Separate departments, separate Director Generals, separate budgets. But in addition to the departments, there's also the entity reporting to the minister, and that is the Private Security Industry Regulatory Authority, CIRA. They are responsible to regulate private security industry under the minister's purview. Finally, in respect of cooperative governance at provincial level, the minister must consult with provincial governments when developing national policing policy to take into account the specific policing needs and priorities of each province. And as I've indicated earlier, the minister chairs the MINMEC committee that consists of the minister and the members of the executive councils responsible for policing. This committee facilitates cooperation and coordination between the national and provincial spheres of government.
Or can I just ask you, as you are about to deal with paragraph 26, you start that paragraph in your first sentence by stating that the need for clarity on the role of the minister has repeatedly been raised as a concern. So as you deal with that paragraph, if I can just ask you to perhaps give examples where this issue has arisen, because you say it arose repeatedly. So if you please proceed to deal with paragraph 26, bearing that request in mind.
Okay. The need to clarify the role of the minister has repeatedly been raised as a concern. It appears that there are different interpretations to words given or words contained in Section 207 of the Constitution that requires the National Commissioner to exercise control over and manage the police service in accordance with the national policing policy and the directions of the cabinet member responsible for policing. According to the Oxford Dictionary, policy refers to a course or principle of action adopted or proposed by government to achieve a particular goal, often outlined in written form or as a clear guideline for conduct. Chair, this relates specifically to the question whether the letter of the Minister on the 31st of December 2024 was a direction given in terms of Section 207 and whether that fell within the purview of the Minister to give that direction. So policy is clearly something that is proposed to further government goals, and it's often outlined in written form. And I believe in view of our discussion on the national policing policy, we all have a better idea of what it entails and also the strategic level of matters that are addressed in that policy as an indication of government's goals and aims.
But if I can just ask you to stop there, perhaps. You recall the National Commissioner said he reached out to the President. The President said he'll talk to the Minister. And then in one of those meetings where this issue was discussed, the National Commissioner says the President is in agreement with the disbandment of his PKTT, and therefore, by extension, the President was in agreement with that instruction that was issued. Does that make any difference in relation to your definition as you've referred to as policy?
Government's policy does not only relate to the decision or view of the President and the Minister, and this is even more pertinent in view of our current government of national unity. So it cannot be proposed that even if it was discussed with the President, it has now become government's policy or government's intention to dissolve the PKTT.
All right. I understand your answer. Please proceed. This appears.
This appears to be aligned to the requirement that the national policing policy requires consultation with provinces to ensure a course of action to achieve a particular goal, in this case to address policing needs and priorities. This is furthermore consistent with the policies already drafted and issued by the Minister of Police, which were written documents and aligned to government priorities, with the aim to provide medium to long-term strategic course of action. In contrast, a direction is identified in the Oxford Dictionary as a position towards which a person moves or points, and refers to guidance or supervision. A direction does not require to be in writing and may also include verbal instructions. It appears to be focused more on immediate or short-term action.
Just on that, General, was the disbandment instruction a direction as envisaged in Section 2072 of the Constitution? If not, why? I am aware that from paragraph 93 onwards, you do deal with the question whether the disbandment instruction was a policy or an operational matter. You do not deal, however, with the question of a direction. That is from 93 onwards. Hence my question.
Okay.
So, was the instruction a direction or not? And why not?
Chair, clearly it was an instruction by the Minister. It also contained the word, I believe repeatedly, direct. The question is, was it a lawful instruction or direction, in the sense that the Minister have the power to direct or command the closure of a task team that was investigating crimes? And in my view, it did not have that authority, because it relates to the operations, investigating cases and the operations of the police. In other words, the execution of the police's mandate in terms of Section 205(3). If we say the National Commissioner is responsible to manage and control the police service, that must be linked to manage and control the police service in the execution of its constitutional mandates. And the decision of the Minister to close a political task team that was responsible for the investigation of crime, in my view, fell outside the mandate or authority of the Minister.
So in short, what may be purporting to be a Section 2072 direction cannot be such a direction if it has strayed onto operational matters.
I agree with that submission or with that explanation, Chair.
Well, if I can just come in, it's not even a question of agreeing. I think the Chair is simply paraphrasing your statement and the proposition that you put.
Okay. I confirm.
Yes. I think, lest the Chair be misunderstood. To say,
Thank you for
a
the
particular suggestion.
Thank you.
Thank you, Chair.
Yes. General, two questions from me. One about directions. What would constitute a direction that does not offend, a direction from the Minister that does not offend the constitutional structure?
Commissioner, in my view, especially if you consider public engagement, such as in BIZOs, will be a place where the Minister engages with the community. And if a Minister, for example, during such an engagement with the community, finds out that there's unhappiness, for example, in the Western Cape with gangsterism, and the Minister tells the National Commissioner, you have to do something about gangsterism, that would be a direction. In my view, it will be a positive direction coming from the evaluation of complaints or engagements that the Minister had, and this can be with the community or it can be with the politicians in the province. And that direction is based on what he was told by members of the community or members of the executive in the province, identifying a specific area of concern or where there's a problem, and simply telling the National Commissioner, you must do something about this, or attend to this, look into this. As I said, gangsterism, I believe, will be an example that all of us can identify with.
Okay, so not the how.
Not the how, no. And I would also be careful to say that the Minister can close things. In other words, that can have an impact on policing. So if he makes a positive suggestion or a positive guidance to say, look, or what can you do about this? But to close something may have a ripple effect that is not something that is anticipated by a politician when that decision is taken, simply because he's not, he cannot be expected to be aware of all the intricacies of policing and how one decision can impact on a number of other aspects of policing.
And the second part, in your paragraph 26, that opening sentence where you say the need for clarity on the role of minister has repeatedly, with emphasis on repeatedly, been raised as a concern. This, I don't know if this is the intention that you sought to convey, but it suggests this is not a once-off, the case that we're dealing with now, the facts that we're dealing with now. It's not a once-off thing. There's been concerns, if you like, systemic concerns about the role of the minister. Is that what you're seeking to convey there? And if you do, if that's what you're seeking to convey, what are the specifics?
Commissioner, to be honest with you, I think it was more within the context of the last couple of months that we've been consistently working and attending to the issue of the closing of the task team and the implications thereof. So there wasn't any strange intention to include the word. I think it's just something that is constantly part of our daily operations. And I believe the implications of that letter and the fact that we are sitting here today indicates the need or amplifies the need for clarity, not only for the benefit of the organisation, but also for the benefit of the executive, to ensure that there's a clear line to stay away from in respect of both the National Commissioner and the Minister, but also for the organisation as a whole.
Your answer suggests that until recently, the recent incidents with past ministers, there's not been the kind of concern about the roles of the minister.
Well, the role of the minister has previously been highlighted, not only in the police, but in the Africa report on the July 2021 unrest, and the fact that the report or the commission held that there was an overstep of boundaries in the roles of the ministers during the policing of or steps taken to address the unrest. So it's not something that is completely new, and it's also not something that's only been identified in the police. It has been identified in other commissions as well. The role of a minister, according to me, is therefore to provide national direction on a strategic level in accordance with government policy. Chair, in conclusion, this structure is intended to ensure political accountability, but insulating the police operations from undue political interference. And I think that is ultimate, the goal of getting that line right, to ensure that there's accountability, but not interference in policing.